Living Trust and Medicaid, what to know. The type of living trust you choose determines whether your assets can pass to your family even if you need Medicaid for nursing home care. A revocable trust leaves your assets fully exposed because Medicaid treats them as if you still own them outright. An irrevocable trust, however, can ensure your assets are retained for your family rather than spent on your care. Because New York enforces a 5-year look-back period, this trust must be properly drafted and funded well in advance of your application. A revocable living trust does not prevent you from having to use those assets to pay for your care before Medicaid begins coverage. A properly structured irrevocable trust can remove assets from your countable estate and protect them for your beneficiaries. A living trust is a legal arrangement you create during your lifetime to hold and manage your assets for specific purposes. You transfer property such as your home, bank accounts, or investments into the trust, and a trustee manages those assets according to your terms. A revocable trust allows you to change the terms, add or remove assets, or dissolve the arrangement at any time during your lifetime. However, because you retain full control over revocable trust assets, they remain legally yours in the eyes of Medicaid. An irrevocable trust requires you to give up control once the assets are transferred, and you generally cannot modify the terms or reclaim the assets. This specific loss of control is exactly what creates the potential to qualify for Medicaid while retaining those assets for your beneficiaries. Under New York law, your trust document must be meticulously drafted with specific language to ensure Medicaid recognizes it as qualifying for asset preservation. New York Medicaid counts most financial resources when determining eligibility for long-term care benefits, including bank accounts, investments, and real estate. For an individual applying for nursing home Medicaid in New York, the resource limit is $33,038 as of 2026. Assets in a revocable trust are considered available because you can take them back at any time during your lifetime. Assets in a properly drafted irrevocable trust are not considered available to be used for your care under Medicaid rules. New York Medicaid reviews all asset transfers made within 5 years of the date you apply for nursing home coverage under the look-back period. Any transfer of assets for less than fair market value during this window can trigger a penalty period when Medicaid will not cover your care. If you transfer your home or savings into an irrevocable trust and then apply for Medicaid within 5 years, the transfer is treated as a gift. New York calculates the penalty period by dividing the total value of transferred assets by a regional rate representing average monthly nursing home costs. The penalty period does not begin on the date of the transfer but starts when you would otherwise have become eligible for Medicaid coverage. Certain transfers are exempt from the look-back penalty, including transfers to a spouse, which can be valuable tools in comprehensive Medicaid planning. At Davies Law Firm, attorneys Frederick P. Davies and William P. Davies help families in Syracuse and throughout Onondaga County plan for long-term care. This law firm guides clients through trust creation, Medicaid eligibility rules, and asset preservation strategies tailored to each family's unique situation. Call Davies Law Firm at 315-472-6511, located at 210 East Fayette Street, Syracuse, New York, 13202 to discuss your Medicaid planning needs today.